Developers Board, David Hacker and Andrew Raby, all partners at Thackray Williams. So as Sandra said, we'll have the questions at the end. So I'll hand over to you, Yildiz, first of all, to introduce them.
Actually, it's Andrew.
It's Andrew. Apologies, Andrew. Over to you.
Oh, seamless, Helen, seamless. And actually, my name's Andrew Raby as well, but don't worry, we'll move on.
Apologies. It's the
no, don't worry. Morning, everyone. In fact, it's afternoon, isn't it now? Nice to have the opportunity to speak to you all again. Thanks to Sandra and Helen, and thanks for the invitation. A number of you may have been on the talk we did back in January, so I will give just a brief introduction about the firm. Thackray Williams is a full-service law firm serving private individuals and companies. We're about 140 odd people in total. Across 4 offices: Bromley, West Wickham, Sevenoaks and London. Sevenoaks and London being relatively recent additions. Sevenoaks about 2.5 years ago we opened that, and London we opened just over a year ago. So we're a growing firm. The services that we offer include wills, probate trusts, conveyancing, family work, the kind of thing that you probably expect from most firms as solicitors. But in addition, we also have strong teams in some more specialist and niche areas, such as employment, enfranchisement, company commercial. We also have a very strong property bias, I would say. Yildiz Patez, one of my partners, is head of commercial property, as you can see from the screen there, and she's going to talk to you shortly. One of my other partners, David Hacker, is head of litigation, and we have got a strong litigation team as well. Myself, for my part, I'm one of the partners in the litigation team as well. I specialise in residential landlord and tenant, acting for landlords mainly, supporting managing agents, dealing with right to manage applications, and also dealing with litigation from our enfranchisement team. Could I have the next slide, please, Sandra? But today I'm primarily talking to you about residential landlord and tenant issues, and that's really dealing with assured short-hold tenancies, people who invest in property who have tenants, some with large portfolios, some people just perhaps with 1 or 2 investment properties. David is going to talk to you about commercial property and pursuing rent arrears, and Yildiz is going to talk to you again on the commercial property side about solutions for landlords and tenants in this sector in the current climate. But my focus, as you can see there on the slide, is residential property and giving you an update on that area. I think when we spoke in January, if you could stay on that slide, Sandra, that's fine. When I spoke to you in January, I ran through in a bit of detail the Coronavirus Act, which came into force in March last year, just as we were going into lockdown. I'm not proposing to go through that in any detail again today, but the Act does remain in force. It affects many areas, but it does have a big impact on my area of work, residential landlord and tenant. So I thought what I'd do is just focus on the current position under the Act and the current position for landlords if they have a problem tenant, and in particular if they have rent arrears that they need to deal with. And in essence, what a landlord will have to do if they've got a problem is ultimately probably serve a notice on their tenant. And there was a key date, beginning of last month, 1st June 2021, when there were some significant changes to what landlords can and cannot do going forward from that date. The most common notice that most landlords will serve is called a Section 21 notice, Housing Act 1988. And pre-COVID, this was a notice which had to run for 2 months. And it's the typical notice that a landlord will serve in order to recover vacant possession of their property for almost whatever reason, and sometimes when there is a breach of the tenancy as well, because it leads to the simplest possession procedure. But during the lockdown period and under the Coronavirus Act, the notice period, previously 2 months, was extended to 3, then up to 6. But as at 1st June and through to the 30th September, that notice is now a 4-month notice, so it's been reduced a little bit. It is vital that you get that notice right, because it would be pretty disappointing as a landlord to get to the end of the notice period, 4 months on, and then discover that the notice is invalid and you have to start again. The second, and probably the other most common notice, is a Section 8 notice. And that's a notice served where there is a breach of the tenancy. Typically, it might be rent arrears. And again, that's a notice affected by the Act, where until recently, the usual notice period was 6 months. Again, a long notice period. Under the Section 8 notice, you're relying on various grounds under the Act for different breach of the tenancy. I've mentioned rent arrears, or it might be antisocial behaviour. And the notice periods vary with the grounds, but the most typical notices are currently from the 1st of June, 4 months, but from the 1st of August, that reduces to 2 months. So it's coming down again, hopefully, and hopefully will continue to come down. The other point to note is that if you have serious rent arrears, and under legislation currently more than 4 months worth of rent in arrears, then actually you can now serve a notice of 4 weeks only, which is getting closer to the 2-week notice, which was typical pre-pandemic. The other really big change, though, that came in on the 1st of June was the fact that landlords who have obtained an order for possession from the courts where they have got a problem tenant can start evicting those tenants again. Back in the autumn, there was an embargo placed on warrants being executed by the county court bailiffs. Just to expand on that, if you have a problem tenant and you serve notice and then they sit tight and you have to issue possession proceedings in the county court to get them out. Once you have your possession order, the next step, assuming the tenant remains in situ, is to issue a warrant for possession, which the county court bailiff will execute by evicting your tenants. So there was an embargo placed on all evictions in around about December last year. That was lifted on the 1st of June. So suddenly bailiffs could start executing warrants again and, I suppose, putting it sort of bluntly, kicking tenants out of the property where there's a possession order in place. My experience has been that this is happening and happening quite quickly. I pinged a number of emails to the various county courts I'm dealing with at the moment on 1st of June, chasing up warrant dates. And I've probably had 5 or 6 warrant dates since the 1st of June. Some have already been executed and some are being executed later this month. So that's 5 or 6 warrants within the first 2 months of that embargo being lifted. So that's good news, because that's actually somewhat more efficient than the position pre-pandemic. Further additional steps that are required for landlords to take where they have a problem tenant is that we must now make inquiries of the tenant to find out about what the impact has been on them of COVID-19, effectively asking them, have they had a problem financially with their job or whatever as a result of COVID-19. It's interesting because that information has to be given to the court. And if you would try and issue a claim at the moment without having taken that step, then the claim will be issued, in my experience, but it won't be served. It's interesting that there's no similar requirement for the landlord to give information about how they've been impacted by COVID. It's just the tenant. I personally always give information to the court about the landlord as well, because some landlords have been adversely impacted by COVID. The other additional step is a review hearing. So whereas before, if you issue proceedings, you'd either get a possession order based on the paper exercise under Section 21, or if there's a court hearing, after a court hearing. But now there's an additional hearing where the judge reviews the paperwork and makes directions. So it's adding to the time it takes and indeed adding to the costs. I suppose perhaps of interest as well is what has not changed in the intervening period. And I think the biggest thing is that communication remains absolutely key for all landlords. It's so important, if you can, to keep in touch with your tenant. I mean, this was true pre-pandemic, but certainly even more so now, to find out whether they're impacted by COVID or any other issues, financial issues. It's always a good idea. And certainly my landlords, who I think have fewer problems with tenants, are very good at keeping in regular contact with their tenants. What I mean by that is probably going to the property once every 6 months, having an inspection, meeting with the tenant, because experience shows that you often, by doing that, identify problems before they become big issues, if you like. And in addition to that, possibly a quarterly visit, well, a quarterly call, quarterly email, maybe a quarterly visit as well. But certainly visiting every 6 months is a good idea. Can we evict tenants now? Yes, absolutely we can. There's a link there on the slide to some excellent guidance. In fact, perhaps surprisingly, some of the government's guidance on all this is actually very good at the moment, so it's worth a look if you're interested in this and if you have a tenant who you might need to be taking action against. But I thought it might be helpful as well just to take you back to the beginning of letting a property and the steps that you need to take just to protect your position. Because landlords will often say to me that the law favours the tenant and it protects them more than the landlord. In this area of work, I would say that isn't the case. I think so long as the landlord is well prepared, gets all their ducks in a row, effectively does the paperwork properly, then they'll normally be able to evict a tenant if they need to. And in fact, they may never need to do that anyway. And I think there's a couple of kind of golden rules, if you like. I'm always astonished by how many landlords come to me with a problem and they didn't take up references about their tenant, or didn't at least follow through on the references. In my experience, there are two types of tenant. They're good and they're bad, or they're bad if you like. I think you need to take references when letting your property and check those thoroughly. Ring the landlord who gave the landlord's reference, ring the employer checking it's genuine, that kind of thing. Meet the tenant. It's also crucial to have a good written tenancy agreement. Doesn't have to be complicated, doesn't have to be lengthy. I see them regularly and they're 30 pages plus, but they don't need to be that detailed or lengthy. But a good tenancy agreement is always useful. The other thing is to bear in mind the landlord's obligations, because, and this relates to pre-pandemic, but over the years, particularly the last 5-6 years, there's been sort of layers of legislation and regulations that have been piled on top of landlords when they're letting property to make sure they do certain things. And a quick brief overview of those, and to list the key ones, because if you get these right, then you're standing yourself in good stead. One is, if you take a deposit from a tenant, you don't have to, but if you do, you must protect that deposit in one of the recognised tenancy deposit schemes, and you must provide the tenant with prescribed information about that scheme and keep evidence of having done so. If there's gas at the property, you must have an up-to-date gas safety certificate, which you need to give to the tenant when the tenancy starts, and you need to get that certificate renewed every year and keep records of doing so and give a copy of the certificate to the tenant. You also now have to have an energy performance certificate, or an EPC, energy performance certificate, for the property you're letting, and you have to provide a copy of that to your tenant. There's also a leaflet that the government produces, which you can download, called How to Rent. I'm not sure it adds a great deal, to be honest, but nevertheless, there's an obligation on landlords to give a copy of that to the tenant at the start of the tenancy. Those 4 items must be addressed and must be dealt with, and you must keep evidence of doing them, because if you fail to do so, you cannot serve a valid Section 21 notice. So you cannot begin the eviction process with a tenant should you need to do so. There are remedies around any failures there, but better to get it done at the start. What I tend to do is attach those documents to the tenancy agreement, so the tenant signs them and everyone knows they've got them. In addition, something new since I was last speaking to you in January, as at 1st April this year, the electrical safety certificate provisions came in, now affecting all tenancies, both existing tenancies and new tenancies going forward. Effectively, every electrical installation in the property has to be checked by a qualified electrician every 5 years. And the other item to mention, which doesn't impact, a bit like the electrical safety certificate at the moment, on Section 21, but a landlord is meant to check that the tenant has the right to rent in this country, effectively that they're here legally and entitled to stay here. If you get all of these things right, you should enjoy a reasonably happy landlord and tenant relationship. And the bonus of that is you never have to ring somebody like me to try and sort out your problems. So it's worth getting it right if you can. I'm happy to take questions at the end, which I think Helen mentioned at the start here. But for the moment, I'm now going to hand you over to my partner, David Hacker, who's going to talk to you about commercial property.
Thanks very much, Andrew, and welcome everyone. I don't know whether some of you joined this webinar back in January. Perhaps unlike residential properties, there's not been huge amounts of changes with commercial. I will deal a bit with where we are now and where the future is, but just to sort of say, really, I think, uncertainty seem to continue to be the overriding features of this pandemic, notwithstanding we're now past Freedom Day and whatever that's going to mean in the coming weeks and months. I'm sure that for many of you in business, the last year and a half or so has been perhaps the most unsettling time that any of you or us will have experienced. At the outset of the pandemic, I really didn't have an idea how business would go. I thought there was a chance things could grind to a halt, but actually, to my pleasant surprise, that did not happen. And speaking personally, my practice has actually been busier than I ever could have anticipated. So I continue to spend a lot of my time dealing with commercial landlords and tenant clients, seeking to help guide them through these difficult times, with a view to them coming out the other end with their businesses in as good a shape as they could possibly hope. I'm pleased to say over the last few months, particularly since the last webinar, I've spent less time dealing with rent issues, although I do wonder whether these issues have gone away or maybe just been parked for the future. So I thought I'd just spend a little time now just reminding those that were on the last webinar and informing those that weren't what the current legal position is, what your rights are, what you can do, what you can't do, whether you be a landlord or a tenant. On the last occasion, I provided some statistics from Land Securities on what was happening with rent payments across their portfolio, and I've updated that now to March this year, and you can see the figures on the slide. The June figures for the June quarter rent are awaited. I think these figures demonstrate, in quite a sobering way, how tough it is. It's still out there. You won't be surprised to hear that retail, leisure and hospitality have paid and continue to pay a relatively small percentage of the rent that they owe. In view of the fact that many of them have been closed for much of the year until this week, those figures perhaps not as low as we might expect. So what is the current situation in relation to rent liabilities? Can I have the next slide, please, Sandra? In essence, when the pandemic hit, the government just put the brakes on actions that landlords could take against their tenants for non-payment of rent. As I stress, this only applies to non-payment of rent. So a landlord cannot currently forfeit a tenant's lease for non-payment of rent. Now that's been extended on numerous occasions and is now, as of June, been extended through to the 25th of March 2022. A landlord cannot exercise commercial rent arrears recovery, called CRA, and that is to the 25th of March 2022. Actually, not what it says on the slide. 25th of March 2022. And a landlord cannot issue a winding up petition against tenant's business for failure to pay rent until the 30th of September 2021. Now, I think it's likely that that's going to be extended. So basically, a landlord's options at the moment are very limited. That doesn't mean the landlord doesn't have the right to claim the rent, and the rent liability continues to accrue. What it means is just that the ability to actually recover that rent is very limited if there are problems. Could I have the next slide, please, Sandra? So what can the landlord do? Well, if you've got a rent deposit, you can draw down on that. There's nothing in the coronavirus regulations to prevent it, but it does mean that you're potentially exhausting that deposit. And whilst there may be an obligation on the tenant to replenish it, it's unlikely they'll be able to do so in the short term if you're having to draw down on it. You could potentially call on a guarantor of a tenant or a former tenant or a guarantor of a former tenant to meet rent liabilities. There's a 6-month time limit to claim against former tenants and guarantors of former tenants. And there are also some other technical consequences of doing that. I have undertaken this process myself for a client in the past few months, and perhaps unsurprisingly, the former tenant was less than pleased to receive a notice from my client about it. If it's a subtenant, it may be possible to serve notice on the subtenant to pay rent directly to you as a head landlord. Okay, there are some complex rules surrounding this, but in theory that's a possibility. There's nothing in the regulations to stop the landlord taking court action against the tenant by issuing a monetary claim at the county court for the rent, but that does involve paying a hefty court fee. And what it will lead to is a judgment for the rent, which you've then got to try and enforce. And if the tenant's not paying the rent anyway, then questions as to how enforceable that that might be. Alternatively, and I think that my colleague Yildiz might speak a bit about this, landlord can try to enter into a payment agreement with the tenant whereby rent is perhaps deferred or waived, and I'll talk a little bit more about that myself in a minute. So that's it really from the landlord side. As I say on the slide, landlords can take forfeiture for other breaches that are not relating to rent. And in fact, I have a case quite ongoing at the moment where we are claiming forfeiture against a tenant for various things, including non-payment of rent. But in order to be able to actually secure possession before March next year, we need to get forfeiture based on non-rent grounds. Okay, could I have the next slide, please, Sandra? Okay, so that was it from the landlord side. So if you're a tenant, what are your, what can you do? I mean, on the face of it, tenants are in a strong position at the moment in terms of the action that the landlord can take. But my own experience over the past year or so, and this sort of echoes something that Andrew was saying about residential, is that tenants who do nothing are storing up problems for themselves for the future. As you can see from my slide, best advice I can give to any tenant if they can't pay the rent is talk to their landlord, and if that fails, continue to try to talk to your landlord. Having any sort of dialogue with your landlord can only help the situation. The landlord may not be happy to hear what the tenant has to say, but in my experience, hearing something is much better than hearing nothing. If you can pay something towards the rent, even if it's fairly nominal, then pay it. It will hopefully help keep the landlord on side, shows goodwill, and acknowledges the fact that the tenant is acknowledges that the money is due to the landlord and that they're doing all that they can to meet their liabilities. You may be aware that there was a code of practice published by the government around the middle of last year governing the relationships between commercial landlords and tenants and how they should act. And it's quite a lengthy code of practice, but much of what I'm saying today is sort of embodied in that. So therefore, best advice for a tenant, try to reach agreement with your landlord, and if you can't, and pay what you can, and if you can't pay what you can, document your efforts, because that may well be useful down the line. Could I have the next slide, please? Thanks. So my recent experience is that most landlords understand that tenants may have difficulty paying their rent, and they understand that tenants cannot necessarily pay all of their rent at the moment. Most of the cases that I've dealt with over the past year or so have involved landlords agreeing to some sort of deferral of rent rather than a waiver or write-off of it, perhaps allowing for the back rent to be paid over the remaining term of the lease. A lot of tenants are asked for rent waivers, i.e. so they don't have to pay their rent come what may. Most landlords that I've dealt with on either side have been understandably reluctant to agree to that. They don't necessarily know how long this pandemic is going to last or how badly affected the tenant's business will ultimately be. And there really isn't any immediate imperative on a landlord to agree to a rent waiver, because they can take their time, see what happens, and then agree or not agree down the line. So all of these options are available to landlords and tenants. And again, in my experience, most of my tenant clients have been paying something towards their rent. So that continues to be the position for the moment. No major changes anticipated, probably until March next year. So whilst court action and the other legal powers that landlords have are restricted, there is the potential and necessity for dialogue at the moment, and I would say this, applies at any time. I think, again, echoing what Andrew said, that is absolutely key. Dialogue. So I've spent a lot of my time over the past year or so negotiating terms between landlords and tenants. I'm hopeful that as a result of those negotiations, parties will be able to maintain good relationships and viable businesses when we are past this and well into the future. So that sort of covers what can be done and what can't be done, and basically what I suggest should be done. I'll happy to take questions, of course, at the end. And for the moment, I'll hand over to my colleague Yildiz, who I think is going to speak in a little bit more detail about the mechanics of all this and what she's been doing over the past year or so. Thank you.
Thank you, David. So I've headed up the commercial property department since 2006. And in the last 18 months of my career, I've seen that landlord and tenant relationships shift significantly towards partnership, with both parties focusing on the success of the tenant's business. Most commercial property landlords now understand the need to work with their tenants to agree mutually beneficial changes to the lease. As David said, speaking to each other about the challenges ahead should be the first port of call, especially as we're now out of lockdown, but there is still uncertainty with regards to COVID. The solutions that I've seen over the last year have been rent concessions, alternative rent structures, and more recently, extensive restructuring of the lease terms. The way in which you can make changes to the lease are temporary and personal by way of a side letter, or a permanent variation, which is binding on all successors in title of the freehold and the tenant's interest in the lease. So first of all, with regards to rent concessions, if a landlord has been approached by their tenant asking for help or even further help if they're unable to pay their rent, what does the landlord need to think about? Is the tenant's business still genuinely in difficulty? There have been winners and losers, and some have pivoted and adapted their business successfully. So not all businesses have been affected in the same way. Is the landlord agreeing to waive the rent, or is it just a deferral? If the rent is being deferred, when will it be paid? The best approach is to agree a timetable for repayment now. Can the landlord agree monthly rent payments to ease cash flow? And if so, how long will this last? And will the landlord want the right to end the concession early? Does the concession only apply to the quarterly rent, or does it include the service charge and insurance? And what about interest? Will this automatically be charged on back payments, or just if the tenant has done something to trigger early repayment, such as breaching the terms of the lease or the arrangement? And the landlord may want to specify automatic events of termination of any kind of arrangement, such as the insolvency of the tenant, breach of the terms of the lease, or an assignment or underletting. And if there is a rent review during this period, what will be the agreed effect on this? From the landlord's point of view, they would not want any negative impact on rent review resulting from the rent concession. And are there any confidentiality issues? If the landlord has more than one tenant, then the landlord might not want the agreement publicised so that other tenants make the same request. So this should be covered in any agreement reached. If the landlord has finance secured against the property, they'll probably need the lender's consent. And lenders are likely to take a pragmatic view, but it's important to talk to them. Any guarantor of the tenant's obligations in the lease should also be joined in, so that they're also bound by the terms of the arrangement. As is the way of things, a simple agreement in principle is never that simple, and care should be taken that an act of cooperation and kindness doesn't backfire on the landlord. And the other types of solutions I've seen are alternative rent structures. As already mentioned, the simplest is the monthly rent payments, but the landlord and tenant must both be clear about whether rent will be paid monthly throughout the term of the lease or if it's just a temporary concession. The alternative rent structure is turnover rent, which is most relevant to retail tenants. Retail tenants are increasingly asking for the rent to be based on their turnover. Typically, there'll be a fixed minimum rent with an additional payment calculated as an agreed proportion of the tenant's turnover, so they'll pay less in difficult times. This arrangement means that the landlord takes on some of the risk of a retail business in this challenging trading environment. Turnover rent provisions in leases are complex and must be drafted carefully. They can only work if the tenant is able to produce timely, accurate trading figures and share them with the landlord. One of the biggest issues is working out what goes in the turnover calculation. This is particularly difficult where a business operates online as well as from a physical premises. The landlord could argue, and I have seen argue, for a cut of the online sales on the basis they may be generated by visits to the physical shop which effectively operates as a showroom. I've also seen some landlords agreeing extended rent-free periods in return for tenants postponing their break dates, and reducing the rent for returning some of the premises, such as the upper parts of the building, which the landlord can then redevelop. Next slide, please. Sorry, the next one. However, despite the best will in the world, with all these types of arrangements, this may still not be enough for the tenant. And if the tenant's business is still struggling, it might be tempting for the tenant to simply hand back the keys and walk away from the lease. However, ending its obligations early under a lease is not that simple. The options that may be available are exercising a break clause, surrendering a lease, or an assignment or underletting. The first thing to check is whether the lease has a break clause, which will give the tenant the right to end the lease early. Timing is critical, as most breaks can only be exercised on specific dates during the lease. The tenant will have to serve written notice on the landlord, and the lease will set out how many months ahead of the break date this must be done. This is typically 6 months. There are lots of possible traps here, especially if the lease sets out detailed requirements of how and where the notice must be served. It's always safest to get a solicitor to check the lease and serve the break notice. If you don't have a break notice, the tenant could approach the landlord to negotiate ending the lease early by surrendering it. The landlord is under no obligation to agree to this, as an empty premises is not an attractive proposition. However, the tenant might find that the landlord has another possible tenant lined up, or they're planning redevelopment or a change of use. If so, it may suit the landlord to bring the lease to an end early, and this is best recorded by way of a deed of surrender. If the tenant doesn't have a break clause and can't agree to surrender, the other option is to look for someone to take on the premises, either by taking over the lease itself or by taking an underlease. Before the tenant starts looking for a buyer and under tenant, the tenant should check with a solicitor whether or not the lease allows an assignment or underletting, as these are sometimes restricted, and in any case will normally require the landlord's consent, which can't be unreasonably withheld. So hopefully I've demonstrated that there are various solutions open to landlords and tenants, and that they should be proactively communicating with each other where possible, coordinating efforts to mitigate against the ongoing impact of COVID. I'll now go through some key negotiating points when taking on a brand new lease or agreeing a renewal in the current economic climate. When a landlord and tenant try to settle the terms of a new commercial lease, each party will have clear objective. The landlord wants a secure income stream and confidence that the property will be left in a good condition at the end of the lease. The tenant wants the freedom to run the business without interference, to control costs as much as possible, and to have some flexibility if their needs change. A well-negotiated lease will recognise these different perspectives and find a balance between them. As we start rebuilding our economy, there's already a greater understanding that landlords and tenants need to work together. A lease negotiation should not be a battle. While there are many potential points of negotiation in a commercial lease, here are some of the key ones to remember. So the first is rent. Only a commercial surveyor rather than a solicitor will be able to advise the tenant on whether the rent levels being demanded are competitive. It's therefore advised to engage a good commercial surveyor. Rent-free periods. Landlords will often agree to a rent-free period at the start of a new lease as an incentive to the tenant. This gives the tenant valuable bit of breathing space to get established in a new premises, especially if the tenant needs to spend money on fitting out. In the current economic climate, landlords are keen to secure good tenants, so it's well worth pushing for the longest rent-free period that a tenant can get. The length of term and the break clause. A commercial lease will be granted for a fixed term, and a tenant will not be able to end it early unless they negotiate a break clause. The tenant needs to consider how long a lease they require in terms of their business strategy and whether it will be favourable to agree some break dates. The tenant may be offered a one-off right to end the lease at a particular year of the term, or may be able to get a rolling break clause so they can end it any time. In the current climate, the landlord is now more open to agreeing one or more break dates. However, the landlord may want to impose conditions which the tenant must satisfy before they can break the lease. For example, complying with the tenant's obligations up to the break date. A tenant solicitor will try to limit this by paying any rent due and leaving the property empty. Repairing obligations. The usual starting point is that the tenant must keep the premises in good repair, so the tenant would have to maintain and fix any damage unless it's covered by the landlord's insurance. If the premises are not in a great condition to start with, or the tenant's taken a short lease, the tenant should try to limit the obligation to keeping them in a no worse state than they are at present. The tenant would then need to agree a schedule of condition with the landlord with photographs and written details, so that could be used as a benchmark later. Alienation, or rather known as rights to transfer the lease or to sublet. As with all aspects of any business, the tenant will want as much flexibility if the tenant no longer wants or needs to occupy the premises. Most leases allow the tenant to transfer the lease or to sublet, but only with the landlord's consent. By law, the landlord must act reasonably, but they're allowed to impose conditions setting out when they may refuse consent. A tenant solicitor will try to limit these to being up to date with the rent and the new tenant or subtenant being financially strong enough to take on the lease obligations. On the transfer of the lease, the tenant may be asked to enter into a statutory guarantee called an authorised guarantee agreement, so that if the new tenant doesn't meet the lease obligations, the outgoing tenant will do so. And therefore, it's just as important for the outgoing tenant to ensure that the incoming tenant is financially strong. Alterations to the property. The tenant should make sure that they have whatever rights they need to alter the property to suit their business. The lease will probably prohibit structural alterations, but the tenant should ask for the right to make internal non-structural alterations, which will probably require the landlord's consent, but they may be able to agree circumstances which consent's not required, such as non-structural, demountable partitioning. The other important element is service charge. Most tenants have to contribute to the cost of services that the landlord provides on top of paying the rent. The extent of services will depend on the property. They typically include things like maintenance of areas not included in the lease, as well as heating, lighting and cleaning. If the tenant takes a unit in a much larger development, the services may be more extensive and cover things like public space, shared access, roads and car parking. The tenant solicitor should make sure there is a clear list of services for which the landlord can charge, and that any right to add extra ones is limited. It's also common to list things that may never be included in the service charge, like upgrades to the property that go beyond what is required. But most importantly, the tenant should try to cap the annual service charge to give them greater certainty, and I'm seeing more of this being agreed in the current climate. An interesting development is rent suspension or rent holidays. When the nation went into lockdown to stop the spread of COVID, many tenants were shocked to realise they still had to pay the rent, even though it was illegal for them to trade from their own premises. As a result, many tenants now want their leases to provide for some sort of rent holiday if the business is forced to close under government instructions due to a future pandemic or some other reason beyond the landlord and tenant's control. This is still relatively new, so the terms actually offered by landlords depends on how keen they are to let a particular property and how much they value the potential tenant. However, I am seeing landlords agree to this more and more. And finally, the right to renew. At the end of a commercial lease, the tenant will have an automatic right to renew, subject to one of 7 statutory grounds that the landlord could use to oppose a renewal. A landlord may try to exclude this right to renew at the very outset, and a tenant should actually try to resist this if they plan to stay in the premises for any length of time. So I hope my summary of the key negotiating points are helpful. Lease negotiations can break down and become slow and expensive if either side is too rigid. A good commercial surveyor and solicitor will help you work out the key commercial issues quickly and concentrate on negotiating the best deal. So thank you for attending the webinar today, and I'll pass you back to Helen.
Thank you very much, Yildiz. Sandra, can I ask if we, yes, take off the things, and then if everyone puts their cameras on, and then we can we see here, can we see the people in the audience? Is it possible to put your cameras on? Oh, someone's gone away. Okay. Although I can't see some of the people, do I see any? I don't see any electronic pause. Nope. Okay, I'm going to fire a question. Excuse me squinting slightly because I've got the wrong glasses on. So here we go. I've got a question of Andrew. My tenant has fallen into arrears of rent and I've not heard from him. What should I do?
I think the first thing is to try and contact the tenant. It's surprisingly common for me to, well, in pre-pandemic days, sit down in front of a landlord and have a first conversation, because it tends to be on the phone or by Zoom. But often the landlord has not actually really made any contact with the tenant, and there's 2, 3, 4 months worth of rent arrears. So ring the tenant, email the tenant, possibly even pop round and see them if you can, avoiding any harassment of any kind, and try and open that communication channel, because it may be that there's a very good reason why they haven't paid. There may be a way around it. You may be able to agree that they pay a smaller amount that month and then make it up. But you know, the point I made in the talk really is communication.
Yeah.
If you get no response at all, then even if you're only looking at 1 month where they haven't paid, I think you should be thinking about taking some advice, because you need to be ready to deal with 2 months worth of rent arrears if they don't talk to you at all.
Yeah, thank you very much, Andrew. So it's the key, isn't it? You know, keep in touch with them, know where they are, and seek legal, professional advice. I've got one more, which was given to me earlier, as they say. I've decided I want to sell my property that I currently let. How do I go about obtaining vacant possession in order to sell?
Okay, I think that's for me as well. First thing to do is to check the tenancy agreement and see if you're still within the original term of the tenancy. Most tenancies will be assured short hold tenancies, and they're usually set up for 12 months initially, sometimes a bit longer, sometimes a bit shorter. If you are still in the initial fixed term of the tenancy, and there's no break clause in the tenancy, then actually for the time being there's nothing you can do about selling your property. I mean, you can talk to the tenants and possibly arrange some viewings perhaps, but you're stuck with the fixed term. Assuming you can bring the tenancy to an end, I would say again, always speak to your tenant first, say that's your plan, you want to sell, perhaps have a conversation with them about whether they are thinking of moving out anyway, and also warn them that you'll be getting they'll be serving or being served with a Section 21 notice, currently 4 months, as I say, to start the process of bringing the tenancy to an end. And then as that notice expires and you get towards typically the last 60 days of the tenancy, you can start making arrangements with cooperation of the tenant to start viewings. But the reality is you won't be able to, or typically won't be able to sell the property or exchange contracts until you have vacant possession. So there may be a delay in the selling process because of the tenant being there. The other thing is, if you've already contacted your solicitor with a view to selling the property, please do tell them there's a tenant in the property, because we've certainly had cases where things have got close to exchange of contracts, and for the first time ever, the client says, "Oh, by the way, I've got a tenant in the property. Is that an issue?"
Oh,
yeah.
goodness.
So kind of back to communication, I think.
Yeah, thank you very much for that one, Andrew. So I think this one is going to be for David, because I'm
okay, far away.
Sorry?
Fire away.
Oh, thank you. And okay, what do you think will happen with the REARS until March 2022?
Well, I think that the government have said that they're going to bring in this arbitration scheme. Effectively, I think what's going to happen is that in some way they're going to sort of ring fence the arrears that have fallen due during the pandemic, and there'll be some sort of scheme in place that will arbitrate over over what period the tenant will pay those arrears. I don't think under any circumstances the government are just going to release the restrictions in March and it will just be a free-for-all and landlords can go in and forfeit leases, because some tenants will by then restrictions would have been in place for 2 years. So I think the government said there's going to be legislation introduced, but I mean, obviously nothing yet, and I'm sort of expecting it to arrive probably around the second week of March next year. Yeah, I think basically there'll be some sort of ring fencing of arrears in some way. Okay,
thank you very much for David. And in a way, this is very similar to the question I asked Andrew. What will happen if the tenant just stops paying the rent?
Well, yeah, I mean, it's difficult. I mean, I was thinking about this when Andrew was answering. I mean, you need to find out whether, I mean, you can't, the problem is you can't forfeit the lease for non-payment of rent at the moment. So, on the face of it, the tenant not being there doesn't help. You need to speak to the tenant and see whether they actually are looking to surrender the lease, if you are prepared as a landlord to consider a surrender of the lease, you may not be prepared to do that. So there may be an issue about potential surrender, but I think that those are the sorts that those. I have had this scenario actually with a client this year, and I would say to a landlord in those circumstances, you need some proper legal advice, because we may be able to argue somewhere there's been some sort of surrender if that's what the landlord wants. If the landlord doesn't want that, then tenant disappearing, yeah, it's a big problem, and there isn't an immediate, an immediate solution to that. Like Andrew said, you need, do all you can to try and find them and speak to them and see what their intentions are.
David, what do you do if a tenant just gives you the keys back?
Well, you got two options basically. You can either accept them and there's a surrender, or not, in which case there isn't. Or there is kind of a sort of a third way house, which sometimes where landlords say, look, I'm not going to accept a surrender of the lease because I don't want to take back the property and all the liabilities that go with it right now. But what I will do is I'll accept keys for marketing purposes only, not for a surrender. We'll market the property. If I find another tenant, then I can take a surrender. I'll take a surrender from you. But if not, then you sort of you remain on the hook. So that's really that you don't. I would say again to a landlord, don't just accept key unless you know exactly what you're doing and you're very happy to take a surrender. I would say in those circumstances, speak to somebody like myself or yielders and make sure that you're covering all your bases.
And what I would add, sorry, David, if the tenant's not paying rent, then they're probably likely to be breaching other terms of the lease, which might give the grounds for forfeiture.
It might do, but then you've got to go through. You have to go through the court processes then, and that whilst there is no restriction on forfeiture on non-rent grounds. I mean, certainly the case that I'm dealing with, where we are claiming on non-rent grounds, there's a lot of hurdles to go through, and looking at timescales, it's going to take a number in that many months, and there are and probably considerable legal costs. But yeah, that is a potential option.
Thank you. So just following on from this, if the tenant doesn't hand back the keys, will they be off the hook, if they assign or underlet?
If they, were you going to answer that, Yildiz?
Well, I'm just saying, if they sign the lease, and it's more likely than not that as a condition of assignment, they have to guarantee the incoming tenant.
Yeah.
So that's why it's really important that the incoming tenant is of good financial standing for the purpose of the outgoing tenant as well. Because what they won't want is the landlord pursuing them for any rent arrears, 1, 2, 3 years down the line, and the guarantee will last for as long as the incoming tenant then sells on the lease, but they may not assign the lease again subsequently. And if you underlet, then you're still liable for the rent under your own lease. So your liabilities stay in place under your head lease. Yeah.
So it's communication, and have a good lawyer.
And the devil's often in the detail as well. So I may have said this on our last webinar. I'll say this to any, literally sometimes a 30-second conversation with me can save the clients all sorts of problems. For example, just handing back the keys. When I might say, just don't do it. Not right now. Let's see where that leaves us. Rather than the landlord coming to me and saying, "Oh, I've accepted the keys back," and where does that leave me? Yeah.
Well, thank you very much. Now, do I have any little electronic hands? No questions? I found this really informative, and thank you very much, everyone.
Okay, thank
Pleasure.
you.
Thank you. Now, I'm just going to give it a little plug, because at the Chamber, some people are going on holiday, I think, in August, but we're not, because we're into training. Oh, there we go. Thank you, Sandra. That's the first one we've got, but we do have others to follow.
Yeah, so yeah, the whole month is training month, and we'll be updating with extra events on the Chamber website on the events page.
Thank you. That was excellent. I love the way you whizzed up the events. So I would just like to thank Yilditz, Andrew and David again for a really interesting session. And thank you very much. And we'll see you again soon. Thank you. And thanks everyone for joining us. Okay.
Thanks for hosting.
Bye.
Thank you.
Bye.